expertise, agencies, governments defer. And I'm going to talk a bit about how that has worked in the context of broadband network management. So that's one category, right? So there's kind of legitimacy obtained over the course of time because of the good work, the good expertise born from the capacity of the institution to collect information, to engage in consensus-building conversations, but also in the sheer knowledge and wisdom associated with the subject matter that agencies and governments don't have. The second is something that's born from a prior commitment that's evocative of constitutional principles, and that is democratic legitimacy. And that is something that I'm not sure, notwithstanding how wonderful the consensus-building process that self-regulatory organizations are involved in, can make the same claim to. Indeed, you know, there are a whole set of cases in the administrative law setting in which courts make a distinction between the deference that we give because of expertise and the deference we give because an institution is a superior and has more democratic legitimacy. And this is part of the doctrine. And you know, Chevron itself, the case that kind of articulates the view about how when courts defer, talks about the fact that judges, for example, have no constituency. We might say the same about agencies. I mean, we might say the same about non-governmental entities. They don't have the same constituency in the same way that the FCC or even better Congress do. So I'll come back to that in a moment. So this takes me to the discussion about broadband network management. So Danny very helpfully, I think, talked about the ways in which the US government put its imprimatur on what it means to have an internet freedom, right? So we have the CDA, Section 230, which immunizes intermediaries for torts when they're just acting as passive conduits, right? Congress decides to do that, include that. Of course, you have the Supreme Court's decision, ACLU v. Reno, about First Amendment. But it's not just that. It's the a crisper articulation of how this deference worked back then, a deference to self-regulatory organizations, is the NTIA's delegation to ICANN, right? And the assumption that ICANN would be a good administrator of the DNS and IANA function. And better, we can also talk about the FCC's regulatory light touch during this early period. These were the components of what I think people thought of as internet freedom. But to be clear, these were components that were at the early period of this medium. Things have changed, right? We've talked about how it's become contested. Indeed, this is a contested space and no longer the sort of thing that we relegate to the boutique sophistication of engineering solely as engineering. Surely that's an important